Welcome. Thank you for joining me today. Michigan Alliance for Families supports families and educators with resources and information about disability and special education issues involving children and young adults from birth to age 26. Michigan Alliance for Families staff assist parents in understanding their special education rights and protections, communicating their children's needs, and finding information to help their children develop and learn. Today I'm talking about the evaluation and eligibility determination process for special education services for students with disabilities. I will be covering quite a bit of information, including federal regulations and state rules, child find, how to determine if your child may need an evaluation, requesting an evaluation, prior written notice, review of existing educational data, consent, the initial evaluation process, the multidisciplinary evaluation team, eligibility for special education programs and services, the individualized education program, parent participation in the evaluation process and IEP meeting, notice of a free appropriate public education and initiation of the IEP, procedural safeguards, and COVID-19 information about initial evaluations. The Individuals with Disabilities Education Act, IDEA, is the federal law governing special education. The most recent amendments were passed by Congress in 2004, with final regulations published in 2006. IDEA is the foundation for special education across the country and sets the minimum requirements. States can do more, but not less. For example, federal law includes eligible students with disabilities 3 to 21 years old. Michigan rules allow for special education programs and services to eligible students with disabilities from birth to 3 years old, and for eligible students without a diploma from 21 to 26 years old. 504 plans are covered by a different law, the Rehabilitation Act of 1973, Section 504. Section 504 of the Rehabilitation Act assures access and accommodations to students with disabilities who may not qualify for special education programs and services. It prohibits discrimination based on disability and has different regulations and a different complaint process. Michigan Administrative Rules for Special Education covers how federal laws are implemented in Michigan. For example, eligibility and student-to-teacher ratios in self-contained classrooms. The Individuals with Disabilities Education Act and Michigan Administrative Rules for Special Education are the foundations for special education. No federal laws or state rules have changed due to the COVID-19 pandemic related to child find, evaluation of a child with a disability or suspected disability, eligibility for special education services, and rights and protections under the Individuals with Disabilities Education Act and Michigan Administrative Rules for Special Education. If a student is eligible for special education programs and services, he or she is entitled to a free appropriate public education, FAPE, provided in the least restrictive environment. Look for guidance from Michigan Department of Education, Office of Special Education, as well as other COVID-19 information on the Michigan Alliance for Families website at www.michiganallianceforfamilies.org/COVID-19. The primary purpose of the Individuals with Disabilities Education Act is to ensure that all children with disabilities receive a free, appropriate public education, FAPE, including special education and related services that are designed to meet their unique needs and prepare them for further education, employment, and independent living. The IDEA includes the Child Find mandate that requires all school districts to identify, locate, and evaluate all children with disabilities, regardless of the severity of their disabilities. In Michigan, this applies to children from birth through age 25. The IDEA requires all states to develop and implement a practical method of determining which children with disabilities are receiving special education and related services and which children are not. This requirement includes all children who are suspected of having a disability, including children who are receiving passing grades and are advancing from grade to grade. This obligation to identify all children who may need special education services exists even if the school is not providing special education services to the child and includes children who attend private and public schools, highly mobile children, migrant children, homeless children, and children who are wards of the state. In Michigan, child find activities are coordinated by early on, birth to age 3, and child find coordinators, ages 3 to 26. When children are struggling in school, it is important to find out why. Your child may have a disability that is affecting his or her educational performance. If so, your child may be eligible for special education and related services that can help. Special education is instruction that is specially designed to meet the unique needs of children with disabilities. Prior to an evaluation for eligibility for special education services, the school may try interventions in the general education classroom and modify instructional practices to determine if that helps your child. While districts may want to try various interventions, it is important to note that the use of interventions cannot delay or deny an evaluation when there is a suspected disability. If interventions and supports provided in the general education classroom that can be provided to all children are not working for your child, you may want to request an evaluation. A parent can request that their child be evaluated, or the school may ask to evaluate the child. A parent's request for an evaluation must be in writing. Parents are often the first ones to notice that their child's learning, behavior, or development may be a cause for concern. If you're concerned about your child's progress in school and think he or she may need extra help from special education services, you can write or email your child's teacher, principal, or director of special education to request an evaluation. If an evaluation is going to be done, the school must evaluate your child at no cost to you. School personnel may ask to evaluate your child. Based on a teacher's recommendation, observations, or results from tests given to all children, the school may recommend that a child receive further screening or assessment to determine if he or she has a disability and needs special education and related services. There is only one reason that the school can deny a parent's request to evaluate their child. The school must reasonably believe there is no evidence the child has a disability. Within 10 school days of receiving a written request to evaluate, and before any evaluation is done, the school must provide you with written notice and request consent from you to evaluate. Prior written notice is a legal requirement of IDEA. It is written information given to parents by the school to explain an action the district wants to take or is refusing to take related to a child who has a disability or is suspected of having a disability. Prior written notice is required whenever the school proposes to begin or change the identification, evaluation, or educational placement of your child, or the provision of a free appropriate public education to your child, or refuses to begin or change the identification, evaluation, or educational placement of your child, or the provision of a free appropriate public education to your child. An example is if the school says, no, we are not going to evaluate your child now. The school must give you notice with the reason for their refusal to evaluate your child. Notice is required prior to the school requesting consent. The information in the notice will help you make an informed decision about providing consent. As part of providing you written notice, the school must explain why it wants to conduct an evaluation or why it refuses, Describe each evaluation procedure, assessment, record, or report the school used in proposing the evaluation or refusing to conduct the evaluation. Explain where you can go to get help in understanding IDEA's provisions, and explain what other options the school considered and why those were rejected, and provide a description of other factors relevant to the school's proposal or refusal to evaluate. It is not enough for the school to tell you that they would like to evaluate or refuse to evaluate your child based on your request. All relevant information about the evaluation must be explained to you. IDEA includes protections for parents and students. Prior written notice for an initial evaluation must include providing you a document called Procedural Safeguards that explains your rights and protections. As part of the initial evaluation process, there may be a review of existing educational data, READ. The READ process may include a review of your child's classwork, discipline record, performance on state or district assessments, observations, and information provided by you, the parent. School districts will use a form to document the review of existing educational data and the evaluation plan, which will outline what assessments, testing, and observations will be done and by whom during the evaluation process. Whether or not a READ is used for an initial evaluation, parent consent for initial special education evaluations must be obtained. The purpose of this review is to decide if the existing data is sufficient or if additional information is needed to establish the child's eligibility for special education programs and services and determine education needs. As mentioned, IDEA requires that the school obtain parent consent before an initial evaluation. The school cannot do an evaluation until you agree in writing with a signature with informed consent. Informed consent means that you have been fully informed in your native language or other mode of communication of all information about the evaluation for which you are giving consent, that you understand and agree to the evaluation in writing, and that you understand that you can withdraw your consent at any time. Parental consent to evaluate is not consent for the initial provision of special education and related services. It is only to allow the evaluation of your child to be done. Evaluation involves gathering information from a variety of sources, including information provided by the parent about a child's functioning and development in all suspected areas of disability. A child must have a full and individual first, or initial, evaluation to determine whether he or she has a disability and may be eligible for special education programs and services. Having a disability does not necessarily make a child eligible for special education services. The disability must affect the child's involvement and progress in the general education curriculum, and the child must need specially designed instruction and related services. The purpose of conducting an initial special education evaluation is to see if the child is a child with a disability as defined by IDEA or Michigan Administrative Rules for Special Education. It's to gather information that will help determine the child's educational needs and to guide decision-making about appropriate programming for the child. A child with a disability means a child who has been evaluated and based on Michigan Administrative Rules for Special Education has a disability under one of 13 disability eligibility categories, and the child who, because of their disability, needs special education and related services. Many children have disabilities that do not require the need for extra educational assistance or individualized educational programming. If a child has a disability but is not eligible under IDEA, he or she may be eligible for protections afforded by other laws such as Section 504 of the Rehabilitation Act of 1973. This child might have a 504 plan to address disability-related needs but will not receive needed assistance under IDEA. A school team of qualified professionals called a multidisciplinary evaluation team, MET, will conduct the evaluation. The evaluations must be comprehensive to identify all the child's special education and related services needs, whether or not commonly linked to the suspected disability category. If appropriate, this could include assessments of health, vision, hearing, social and emotional status, general intelligence, academic performance, communicative status, and motor abilities. The evaluation must use a variety of assessment tools and strategies. Tests alone will not give a comprehensive picture of how a child performs or what he or she knows or does not know. Only by collecting data through a variety of approaches, such as observations, interviews, tests, curriculum-based assessment, and so on, and from a variety of sources, parents, teachers, specialists, and the child, can an adequate picture be obtained of the child's strengths and weaknesses. The evaluation must consider information provided by the parent. The evaluation process must be completed within 30 school days from the date of receipt of the parent consent to evaluate. A multidisciplinary evaluation team, MET, will complete a full and individual evaluation of the child, meet to review information about the child, and prepare a written report to be presented to the Individualized Education Program, IEP team. The MET must include a minimum of 2 people who are responsible for evaluating a student suspected of having a disability. The team shall include at least 1 special education teacher or other specialist who has knowledge of the suspected disability. Specific members of the MET are outlined in the eligibility category rules of the Michigan Administrative Rules for Special Education. The MET may also include additional members based on the suspected needs or disability areas of the child. The report must include the information needed by the IEP team, including the parent, to determine eligibility, present level of academic achievement and functional performance, and the educational needs of the student. The present level of academic achievement and functional performance includes your child's scores on tests and other evaluation procedures compared to other children of the same age and grade. The multidisciplinary evaluation team will make a recommendation about whether your child meets eligibility requirements for special education programs and services. The Michigan Administrative Rules for Special Education defines 13 categories of disability and criteria for eligibility for each category. A child must meet the requirements in 1 or more of the disability categories to be eligible for special education services. The disability must affect the child's involvement and progress in the general education curriculum, and the child must need specially designed instruction and related services. The child's IEP team, including the parent as a member of the IEP team, determines a child's eligibility to receive special education programs and services. IEP teams must not use the lack of appropriate instruction due to the COVID-19 pandemic as a sole factor in determining eligibility. The IEP team must include appropriate school and district staff and the parent. If appropriate, the child is a participant on the IEP team. You or the school may also invite anyone else who has specific knowledge or expertise about your child. This person could be your child's private therapist, a community mental health supports coordinator, or an advocate. After reviewing the information presented by the multidisciplinary evaluation team, an IEP meeting is held, and the school must provide the parent with a notice of an offer of FAPE or determination of ineligibility. If the evaluation results indicate that your child meets the definition of 1 or more of the disability categories and needs special education and related services, the results will form the basis for developing your child's Individualized Education Program, IEP. The IEP team must then develop an IEP to address your child's unique needs that result from his or her disability. From the time a parent signs consent to evaluate to the notice of the offer of a free appropriate public education or the determination of ineligibility must not be more than 30 school days. Schools must take steps to ensure the meaningful participation of parents in the IEP meeting by notifying the parent of the meeting early enough to ensure that they can attend and scheduling the meeting at a mutually agreed upon time and place. If face-to-face meetings are not feasible or practicable, schools may need to conduct meetings through teleconferencing or virtual methods. Meaningful participation may need to include parent training on technology being used. The district must do whatever action is necessary to ensure that the parent understands the proceedings of the IEP team meeting, including arranging for an interpreter for parents who are deaf or hard of hearing or whose native language is other than English. Within 7 school days from the date of the IEP meeting, the school must provide the parent with the notice of an offer of a free appropriate public education or determination of ineligibility. After receiving the initial offer of FAPE, a parent has 10 school days to sign consent for initial special education programs and services. Unless a parent has filed an appeal, the school must initiate a proposed IEP as soon as possible and not more than 15 school days after the parent receives notification or not more than 15 school days after receiving parent consent. School and parents may agree to a later initiation date for the proposed IEP if the later date is clearly defined in the IEP. This chart is a summary of the timeline for initial evaluations from the time of the school's receipt of the request for an evaluation to the offer of a free appropriate public education or determination of ineligibility to the initiation of the proposed IEP. You have options under your procedural safeguards if you disagree with the results of the educational evaluation of your child, which was completed by the school. You have the right to an independent educational evaluation, IEE, which is like getting a second opinion. Your request must be in writing, signed and dated, and the school must respond to your IEE request within 7 calendar days of receipt. The district may grant your request for the IEE or initiate a hearing to show that its own evaluation was appropriate. If the district grants your request for an IEE, it is completed at no cost to you and is conducted by a qualified examiner who is not employed by the school district responsible for educating your child. The school either pays for the full cost of the evaluation or ensures that the evaluation is provided at no cost to you. Parents can only request an IEE after the school completes an evaluation and the parent disagrees with the results. The school may ask why you object to the evaluation. However, the school may not require you to explain, and it cannot unreasonably delay either providing the IEE at public expense or initiating a due process hearing to defend its evaluation. If you ask for an IEE, the school must provide you with the information about where an IEE may be obtained, how to get reimbursed, reasonable and expected costs, and that you can choose your own evaluator. You have the right to have your child independently evaluated at your own expense at any time. The results of this evaluation must be considered by the IEP team. If your child is found ineligible for special education services, you have other options under your procedural safeguards. You can request mediation, and you have the right to file an appeal of the decision of ineligibility through a state complaint or a due process complaint. When initial eligibility cannot be determined due to the district's lack of ability to conduct in-person assessment and observations, for example, when a district is in phase 1, 2, or 3, the district is encouraged to develop a contingency learning plan for a child who is not yet eligible. A contingency learning plan is developed by IEP teams in collaboration and with agreement from parents to explain the special education and related services the district is able to provide during the pandemic when full in-person instruction is not able to be provided. For students not yet eligible for special education services, the contingency learning plan should be based on the suspected disability and the needs that resulted in the request for evaluation. Through the contingency learning plan, the IEP team should describe the special education and related services as the offer of a free appropriate public education during remote instruction in accordance with the IEP until the school resumes in-person instruction. A free appropriate public education may look different for virtual instruction than it does for in-person instruction. If the IEP team, through the review of existing educational data, the READ, identifies an evaluation plan that requires in-person assessment or observations that cannot occur during the remote instruction, the evaluation would need to be delayed until school resumes in person and necessary evaluations can be completed. The Michigan Alliance for Families website has resources and information about all of the evaluation and eligibility topics I discussed, including a YouTube video titled FAPE and COVID-19, What Families Need to Know, that explains free appropriate public education and what this may look like during the COVID-19 pandemic. Our COVID-19 information and resources are updated regularly. Michigan Alliance for Families is here for you. We have a comprehensive website that includes special education and disability-specific resources, including an e-newsletter, as well as information and resources related to COVID-19. Statewide virtual events and learning opportunities are being offered throughout the year. You will find links to our on-demand webinars and YouTube videos on the website. We have an archive of recorded webinars available for you when you need access to learn, understand, and manage topics related to special education. We also have several COVID-19 videos addressing special education issues and returning to school considerations. Our materials and events are free to parents, caregivers, and educators. If you need individualized assistance, we have regional parent mentors around the state ready to help you. They are available to talk to parents and professionals about special education and related services and disability-specific information. Find your regional parent mentor on our website by going to the About Us tab or by calling 800-552-4821. Through the magic of technology, you will be sent directly to the regional parent mentor in your area. Thank you again for joining me. We hope your family stays healthy and safe.